Welcome to Data Sovereignty Along the Digital Road. I'm Madhavi Sunder, Associate Dean for Graduate and International Programs at Georgetown Law. In the year 2000, Georgetown professor John Jackson argued that a key goal of the international legal order now must be to, quote, manage economic interdependence, what some people call globalization. If we are to create a robust international order that can meet our global challenges, we will need to work together. I'm honored to introduce the deans of two of the world's leading law schools who are here to help us kick off this global collaboration. Dean Hao-Ling Fu is the Warren Chan Professor of Human Rights and Responsibilities at the University of Hong Kong. He's a widely published scholar on issues of human rights and reform in China and a leading expert on the constitutional status of Hong Kong. Please join me in welcoming Dean Fu.
In China, colleagues, ladies and gentlemen, good morning or good evening. First of all, I wish all of you a healthy and a happy 2021. I was going to say that I trust 2021 will be a year of hope for all of us to return to some sanity and normalcy. But then given the mass arrest in Hong Kong this morning and what may happen on street in the DC, I'm far less hopeful today than yesterday. Nevertheless, I'm so delighted to welcome all of you to this conference on behalf of the Faculty of Law at the University of Hong Kong. It's our honor and privilege to co-host this conference with Georgetown Law Center. There are many similarities between our two law schools, except the age. I want to take this opportunity to congratulate the Georgetown Law Center for its 150-year anniversary. We just celebrated the 50 years anniversary and we thought we are an old institution. Right? So 150 years, what a history, so congratulations. Both, except the history, there are many similarities. Both law schools are near the highest court and the legislature. We are 5 minutes away from our highest court, 10 minutes away from our parliament. And both law schools pay great attention to public interest law and experiential learning. And so we are also very strong on constitution and in particular, national security law research. And of course, we are both very strong on law and technology. At least on our part, we try to be very strong in this emerging field. I hope this event would open many other doors for closer cooperations between our two law schools. Many experts have said before that data is the future, data is the destiny. So I'm so happy that the conference is able to invite so many of the best minds in the field to speak to us. This is not my area, so I cannot say too much about the topic, except that I like the title of the conference very much. Data Sovereignty Along the Digital Silk Road. Oxymoron is good for conference titles, for book titles. My favorite is Justice in the Third Reich. But we don't have to go that far in history to discover real or false paradox. At Hong Kong U, we teach one country, two systems. We teach socialist rule of law or authoritarian constitutionalism. So then, and so on and so forth. I thought we are unique because of our political circumstances, but a casual check on Georgetown's website, then you discover national security and the law and the democratic capitalism. Right? Without further ado, I'm looking forward to the exciting conference. I'm very eager to learn from Hao Chen Professor Chander and the team to put the square peg of data sovereignty into the round rabbit hole of the digital Silk Road. Thank you for your attention.
Thank you so much, Dean Fu. Dean Bill Trainer holds the Paul Regis Dean Leadership Chair at Georgetown University. He is a widely admired scholar of constitutional law, property law, criminal law, and intellectual property. Please join me in welcoming Dean Trainer.
Well, thank you very much, Dean Sunder, and thank you for your great leadership of Georgetown's international and graduate programs. And I'm delighted to be here and to be part of the welcome. And I also want to thank Dean Fu for the collaboration that we have today between Georgetown University and the University of Hong Kong. As the Dean has said, we are schools that have so much in common. We are both great academic centers in two of the most dynamic cities in the world. And we have similar focuses on the relationship between government and capitalism and national security. So, you know, it's a very important collaboration for us at Georgetown, and I'm delighted that we're working together on this conference. And I'm looking forward to the conference that we're going to have over the next 2 days. There could not be a more timely topic than data sovereignty along the digital Silk Road. You know, like Dean Fu, this is not an area of my scholarly work, but as I was thinking about what we're going to be discussing, I reflected on what I have written about, which is constitutional history of the United States in the late 18th century. And it was a transformative period for us. It was the period of the Declaration of Independence and the Constitution. And as we were thinking through our legal systems, it was also a moment of economic transformation. It was really the rise of the market revolution. And so there were two things that the United States government leaders were doing. One is they were actively engaged in conversations with people from outside the United States. So founders like Governor Morris and Benjamin Franklin and Thomas Jefferson and John Adams all were ambassadors outside the United States. And they brought what they learned from those discussions back into shaping American laws. And it was also a period of extraordinary study of legal structures outside the United States. So James Madison was very focused, you know, as he was thinking through the Constitution, on what government structures were in other countries. And I was actually recently looking at the very first judicial review case by the United States Supreme Court. And it actually turned in large part on the Supreme Court writing about Adam Smith's Wealth of Nations. So just as there was a tremendous amount more than 200 years ago to be learned from conversations and study outside the United States, at a moment of economic transformation, we find ourselves again in a moment of economic transformation, and dialogues are more important than ever. So, I can't wait for the 2 days of discussions. I want to thank, in addition to Dean Fu and Dean Sunder, the people who put together this conference. I'd like to acknowledge from Georgetown, Hilary Brill, and I'd like to acknowledge Professor Anupam Chander for their great work, and Hao Chen Sun from the University of Hong Kong. We have an extraordinary group of speakers. I know it will be a very informative discussion, and I look forward to its beginning. Thank you all for being here.
So thank you very much, Dean Trainer, for wonderful remarks. And thank you very much, Dean Fu, for contextualizing this morning within the kind of international developments, both in DC and Hong Kong. And thanks again, Professor Sunder, for your leadership of the international and graduate programs here at Georgetown. I have the privilege and honor of introducing our next speaker, who has appeared on screen, and you can guess who this is because he is known on the street by all law professors in the Legal Academy worldwide. And it's, of course, Frank Pasquale. Frank is one of the leading intellects in internet law. He is one of the most prolific scholars in this area. And more important than that, he's written some of the most foundational work in the area. And he's really caused us to think very hard and deeply about issues of justice and equality in the law, framing our new technological world. And so it's a particular delight to have him give a keynote. Frank is a professor of law at Brooklyn Law School. I should first indicate the institution that pays his regular salary, and I'd acknowledge them and thank them. Though I think any university would be privileged to have Frank on their professoriate. Frank is also the author of the widely acclaimed book, The Black Box Society, which I think has shaped so much thinking about the issues across the world. And he is the author of a new book. I don't have a copy of The Black Box Society because it's in my office. It's well dog-eared, but it was left there in March. But I do have a copy of Frank's new book, which I heartily commend to you as well, will be equally important as The Black Box Society: The New Laws of Robotics, Defending Human Expertise in the Age of AI. And Frank, I am working on a review eventually of this as well. So it's again my privilege to introduce my dear friend Frank Pasquale for the opening keynote for this conference. Thanks, Frank.
Oh, thank you so much, Anupam, for such a generous introduction. I really appreciate that. And I just wanted to also just remark how much I appreciate the opportunity to speak with such an august group and at the invitation of Hong Kong University and Georgetown University. Many thanks to Deans Fu and Trainer for very insightful opening remarks, and to Professors Sun and Chandra and Sunder. All of you have inspired me with your great scholarly contributions, and so I really appreciate this opportunity to speak today. Well, I will just dive right in to some slides that will help guide the conversation today, or my presentation, and then perhaps some questions afterward. And just in thinking about this concept of from territorial to functional sovereignty, the essential idea here is a relatively straightforward one that governments that have control over territory are increasingly ceding power over increasingly important aspects of life happening online, digital life, and the life of data, to what I've deemed functional sovereigns, to entities that have control over certain slices of life, certain functions in life, be it finding rides via ride-sharing apps, housing or hotel or short-term stay apps, the online public sphere, other forms of search, social networking. These are all functions that we all need performed. And increasingly, the leading firms that do perform those functions have a form of sovereignty over them. And in a recent piece for the Maryland Law Review called Six Horsemen of Irresponsibility, I sort of talked a bit about the legal forms that enable this type of functional sovereignty to develop more and more. I originally developed these concepts in a talk for the think tank of the CDU in Germany at the Friedrich Ebert Stiftung in Germany. And what I want to do in today's talk is to both review, where we've come since 2017 in functional sovereignty. I think if anything, the trends have accelerated in many respects economically. But also I see that over the past 3 years, I think there's been a very significant trend in Chinese, Australian, and US competition law, and of course in European competition law, which predated 2017, to rein in functional sovereignty. And what I want to reflect on at the end of the talk is the degree to which this invocation of competition law involves a politicization of antitrust or of competition law. I think it does, and that's usually thought to be a negative thing. But what I'll try to conclude with is the idea that there are two faces of politicization, and that at least several of the recent actions with respect to competition law to address functional sovereignty are quite thoughtful and reflect the best of politicization rather than the negative side of politicization. So to set the table for the concept of functional sovereignty, I love starting with a quote that got the Airbnb CEO in a bit of trouble a few years ago. There were these local housing ordinances that would say things like, you can't rent your unit for more than 30 days, or there's a minimum price, or there are taxes, or things like that. And the chief executive of Airbnb compared the firm's defiance of local housing ordinances with that of Gandhi's passive resistance to British rule. And I was recently reading this wonderful collection edited by Ramachandra Guha, called Makers of Modern Asia, sort of discussing the long history of Gandhi's career. And, and having just recently reviewed that, I just find it so troubling, that someone would compare this relatively picayune defiance to one of the great movements in human rights and human history. But it's happened again in the US when another tech leader compared Uber to civil rights leader Rosa Parks in defying unjust laws. And at the time, both companies were really taken to task. But what I find rather remarkable in terms of recent political developments is that gig economy firms recently overrode worker protections via a plebiscite, a referendum of the people with quite a large margin in something called Prop 22 in California. And it was quite a remarkable form of a referendum, because what it essentially did is it not only overrode many worker protections, it did give some worker protections back, but it overrode many important ones that were called for by activists. But it also said that the legislature, to amend relevant legislation, would need a 7/8 majority. Okay, so it's a very interesting form of what Nancy MacLean chronicled in her book, Democracy in Chains, about the movement of James Buchanan and others, to sort of encase the democratic state via very strong constitutional rules, right? The same type of thing that Quinn Slobodian talks about in his work, Globalists in Contrasting Imperium and Dominium, the rule of dominium under neoliberals as opposed to imperium. And so these trends, I think, are quite important to remark, because I think that they portend a larger effort by large technology firms to challenge, now it is labor protections, but I think in time to challenge data protections and other forms of regulation to essentially render themselves functionally sovereign over different slices of life. Now, in thinking about the politics of platforms, some may say this is a good thing, right? In terms of a conventional view, the idea is that platforms promote fairer labor markets by enabling lower cost entry. Large digital platforms have gained massive market share because of their quality of service. So that is a conventional narrative that I talked about, a few years ago in the Two Narratives of Platform Capitalism paper. But I think that we can't just tell a positive narrative of platform dominance, because they also promote precarity by reducing the bargaining power of workers. And when concentration gets high enough, consumers tend to be troubled as well. There tends to be a chipping away at whatever consumer surplus was accumulated via the squeeze on suppliers and labor. And so therefore, I think that, and we have to also finally recognize that it's not always just a story of the best getting to the top. A lot of times luck, first mover advantage, network effects, all of the strategic lawlessness, and of course the unusually low cost of capital is a huge aspect of the rise of many of these platform firms. So there's a pincer movement where I think that another aspect of functional sovereignty is putting together public cooperation and private rivalry, right? So the public cooperation side is to offer technical assistance to government to achieve its goals, to supply expertise on data management, AI, and other concerns for the development of smart cities. Again, this is the idea where I began with a sort of tech firm or platform assault on the state. There also are efforts to help the state, but behind all the efforts to help the state is sort of lurking in the background this private rivalry, a lobbying to change or limit the goals of government by discrediting regulators as, say, too slow or unimaginative. So for example, in New York, when there was an effort to really regulate ride sharing, in particular Uber being the dominant firm, people who opened their Uber app would see these messages saying that, you wouldn't get this service at all. We either provide it in this sovereign way where we're really unfettered by very large swathes of regulation, or you get nothing, right? Now, this revolving door, say, between government and large firms, or sort of cooperation between them, is relatively old. I think what's relatively new in digital capitalism is the move of so many firms from being market participants to market governors, okay, to sort of saying that we're not just one participant in the market, but our business plan, the whole premise of why it makes sense, for example, for SoftBank to invest tens of billions of dollars in, say, a large ride-sharing firm like Uber, is that eventually it becomes sort of the governor of transport and logistics in a very important sense. And this is the move, I think, from territorial to functional governance. Now, of course, I'm not claiming originality for this type of thought. I mean, it goes all the way back, of course, to Robert Lee Hale and Freedom Through Law, saying that there's government whenever one person or group can tell others what they must do, and when those have to obey or suffer a penalty. So that sort of great legal realist insight has always been there. It goes back to the 20s. I'm sure if I were better versed in European law, there would be examples from German, French, or British discourse, to say the least, that would perhaps talk about this idea. But I think that it's nevertheless, it's important to demarcate this idea of sovereignty now, and to sort of bring in the idea of sovereignty, because that's really the ultimate stakes here, is who's in charge, who gets to say what. And the other side of it that I think is quite critical to remark upon are people like Martha Minnow's and Paul Verqueel's critiques, and John Michael's most recently, critiques of outsourcing of governmental functions, of potentially inherently governmental functions to some of these entities. Another form of sovereignty that they seem to be attaining. For example, in a firm like IBM, potentially proposing that its software or scoring system can give European governments an answer as to whether someone seeking asylum is a refugee or a terrorist. Right, or any sort of collaboration to rank and rate individuals via a unitary score. Those sorts of scoring system as well could be sort of a harbingers of a certain form of sovereignty over reputation, which is yet another dimension of this functional sovereignty. I've started the talk thinking about goods and services, but there are also ways in which, of course, reputation and search, the big topics of my Black Box Society book, where that form of functional sovereignty is also appropriate to remark on. It's remarkable too how sometimes in Silicon Valley there are fables of extraordinary functional sovereignty. So for example, in Max Tegmark's Life 3.0, I'm not saying that he is endorsing this, he's just sort of bringing it up as what I would call social science fiction, following Peter Frase's work for Futures. You know, there's this idea of that you can write something that both is science fiction but also grounded in current social science. This idea that perhaps, you know, social services would just be provided by idealistic companies rather than the state. We saw a little bit of talk of that in the US after Katrina, when the catastrophic Bush administration response led Walmart to come in and to provide a lot of relief. But this is a whole nother level in terms of thinking about that form of sovereignty, and even helping people in the states of emergency when the state is thought of as being most needed. But the problem is, of course, that this takeover is not going very well so far. So for example, this is an example from Kat Ferguson, who reported in The Verge on Google's referrals to addiction clinics in the US. And so what was happening in the United States and is still happening is there's a terrible crisis of an opioid epidemic. So you could almost think of it as an opium war by the Purdue Pharma against the American people in this sense. And in this way, this opium epidemic has become, you know, a real problem in the US, and lots of people are seeking help or were seeking help. And they would go to Google and they would Google for certain forms of assistance in the help of like addiction centers, et cetera. Well, it turns out in the addiction center universe, if you spend most of your money optimizing your search position on Google and very little on actually taking care of people, that has turned out to be a very good business model for several entities. And so what happened was, at first Google was, and it's notable to note that, you know, to the extent that in the past, say, private insurance companies or state insurance companies, in the case of Medicare or Medicaid in the US, would be governing the referral of individuals to these types of addiction clinics, as people just wanted to just Google it. That sort of quest for convenience or quest for just immediate assistance led to a certain form of sovereignty over those referrals. And first, Google's response was to stop allowing paid ads. Okay, so they wanted to sort of wash their hands of the entire situation. But then it turned out that their crowdsourced listings of phone numbers and other maps to get to addiction centers were themselves being taken over by people that were pretending to be helpful referrers or helpful raters and rankers online in the manner of The Crowd in Brynjolfsson and McAfee's book, Machine Platform Crowd, but who were in fact just being paid by the sketchy addiction clinics. And this leads to a problem that is often referred to in the monopoly or anti-monopoly literature as the problem of absentee ownership, right? Or the problem of a failed state, to take my functional sovereignty metaphor too far. And that's the worry that we have, I think, with some of these addiction referral clinics. We also see a certain functional sovereignty over the public sphere in firms like, say, Facebook or Google, and increasing worries about that displacement of revenue and therefore of power and ability to have reach from traditional media to social media. And some of these predictable results of an automated public sphere, which is afflicted by absentee ownership, and which I go into in chapter 4 of New Laws of Robotics, my new book, is that you're going to see more and more conspiracy theories, et cetera. Of course, the conspiracy theory I have on this slide was back from a few years ago. This was when Obamacare was supposed to be providing or injecting RFID chips into people. Now it's been repurposed into the coronavirus vaccine is injecting people with RFID chips, which on some level may seem, to anyone educated about these matters, a matter of humor or just a unique pathos of an utterly uncontrolled public sphere. But on the other hand, when you see that in some areas of Ohio and California, 20 to 50% of healthcare personnel are refusing to get the coronavirus vaccine or the COVID vaccine in the US, we can see that this is not just a problem of people having irresponsible speech online, but could in fact plunge the US and other places affected by vaccine hesitance into long-term, not only long-term public health problems for their own citizens, but also effectively turning these realms into places that have an uncontrolled infection for longer and longer, leading to the spread or the development of mutated versions of the coronavirus, which we saw within the new variant of B.1.1.7 out, which is commonly attributed to the UK. So these are serious problems, right? This isn't just something that's happening online where it's just cheap speech. It's very serious problems. So now we have to think about some solutions. And is competition law the answer? So in terms of addressing some of publishers' and readers' concerns, one thing I would highlight is the ACCC, the Australian Competition and Consumer Commission, has been working on draft laws to require Google and Facebook to pay for news. So entities that are, say, more responsible actors or that at least have a better person to message ratio would be given more ability to have power and revenue in that situation. It could also, as Professor Catherine Kemp of UNSW has noted, it could help address some of the data issues that we're all so concerned about in terms of and this, of course, is something that was also recognized by the German antitrust authorities, that one of the reasons we have such a bad data deal online is because when you have monopolizing or duopolistic providers, there's not much pressure for them to improve much in terms of their treatment of data. Also, in the US, there's a lawsuit led by Texas and I believe at least 12 or 13 other states, mainly red states, but also I believe California is now petitioning to be involved in this lawsuit, accusing Google and Facebook of essentially rigging the market for ads. I saw one antitrust expert say that if this were in, say, another context, it would just be called bid rigging, and jail time might be on the table as a possible sanction. But of course, this particular suit was styled as a civil suit, and that's not on the table. But nevertheless, it's a rather significant step forward in competition law. In terms of larger, efforts here, and certainly Tim Wu's book, The Curse of Bigness, was inspirational here. I reviewed that a few years ago. Lena Khan, there's an amazing panoply of scholars who've been working in this area in the US. You have the social trust being taken on in FTC versus Facebook, a bipartisan complaint involving the Republican chairman and two Democratic members, a search trust in US v. Google and state lawsuits, and of course the Texas lawsuit that I just mentioned. We also see in China some steps with respect to digital platforms. For example, very recently, TechCrunch reported that the State Administration for Market Regulation said in a brief statement that it's investigating Alibaba over its choose one from two policy, which merchants said forced them to sell exclusively on Alibaba and to skip platforms like JD.com and Pinduoduo. Professor Zhang's book, coming out in March next year, will explore the vast administrative discretion possessed by the Chinese government in areas like this. Now, American antitrust, this sort of reflects the question of administrative discretion and the question of, how exactly did these lawsuits come about in the US, raises the question of politicization, right? And I think that under establishment antitrust doctrines in the US, the legitimacy of antitrust since the rise of the Chicago School has been grounded in determinacy via quantification and something I would call, following Jason Blakely and Mark Bevere, naturalist social science, and it criticizes politicization. But you can see, in appeals like Zephyr Teachout's Break 'em Up, and in what's called the Neo-Brandeisian antitrust school, both in its Jeffersonian and Hamiltonian manifestations, that embraces politicization. And what I want to say in these final words is, should we be embracing or suspicious of politicization? There are some legitimate concerns about US antitrust politicization. So for example, in cases involving cannabis, there's a whistleblower at the Department of Justice who issued a complaint calling attention to second requests, which are just very burdensome document requests. They can maybe cost hundreds of thousands or millions of dollars in many cases. And he claimed that they were not bona fide, but they amounted to almost 30% of the antitrust division's full review merger investigations. And one noted professor in the US, Professor Carrier, said, this is quite remarkable because they couldn't be based on bipartisan antitrust principles, given that the firms involved represented a market share of 0.35%, a very small market share. You'd have to go way back in US antitrust history before those sorts of things would be, I think, really part of the agenda. And there's also was concern about the divergent responses to the Disney/Fox merger and the AT&T Time Warner merger, where there was sort of open arms to the one involving Fox, which is sort of has been referred to as the state media in the US over the past 4 years. And the AT&T Time Warner, which was looked upon with more suspicion. Well, I think that politicization has two faces, and just in the final minute or so, I would say that there's an authoritarian and a democratic face to politicization. And I think that if we were to think about using antitrust simply to punish companies that the current administration does not approve of, that really does reflect an authoritarian, autocratic, ultimately Schmittian approach to antitrust. And I realize that Carl Schmitt is a controversial figure. It is something sometimes somewhat extraordinary to invoke him, given his role in the Nazi legal regime in the 1930s. But Tamsin Shaw had a recent article calling US Attorney General Bill Barr the Carl Schmitt of the Trump administration. And I think there are some ways in which the Schmittian approach, which is decisionist, which says that ultimately what politics is about is helping your friends and punishing your enemies, that did show up in some of those politicized merger responses. But I think that if we were to look at the US situation and the belated efforts to go after and to really understand the problem of tech monopolization here, that does reflect a more democratic and deliberativist approach. And I think that, inspired by the work of Jürgen Habermas and Jane Mansbridge, we can discern in the administrative state working well brings together both legal regularity, scientific expertise, and democratic consultation. And I think what's been really remarkable and rewarding over the past 15 years is that, I think in the mid-2000s, there was an antitrust establishment that was really pretty impervious to complaints of, say, small and medium-sized enterprise when facing larger and larger firms that were using sharp business practices to take more and more market share. And they taking market share, I think, more on the basis of their market power than on the basis of real advances in productivity. And I think that out of that sort of concern, that it helped inform the expertise about antitrust, so that now, there are at least 20 people concerned about this, that I could name off the top of my head. When, I was testifying before Congress in 2008, there was almost nobody concerned about it. And I was, it was just very lucky to have been able to do so, so early on, because there were so few people concerned about it. But I think that essentially is, what's going on here, is that there is a way, and we see this in many different areas. We see this, for example, in health law, the way in which activists can work to better improve the science and the expertise in health, and that science and expertise can itself, in turn, better inform those in charge of the law. And so my ultimate hope here is that rather than dismissing competition law's new turn to address the growth of functional sovereignty as politicization, that we can identify two phases of politicization, and that, my bottom line, that there should be a qualified endorsement of competition law as a check on functional sovereignty. So with that, I will stop my share. I, again, so appreciate this opportunity to comment and to have such a diverse and well-informed audience. And I look forward to a Q&A if brief, but and also if you can't get your question in now, please just reach out to me. I'm just at Frank Pasquale on Twitter, easy to contact. So thanks.
Frank, thank you for that tour de force. I should have also mentioned your alma mater, which is one of the kind of signal things about you, because you share the same alma mater as Stacey Abrams. And so thank you very much. And Frank, let me ask the first question, and I'm gonna, I think we're, we have very little time allotted because we've squeezed 2 full days of conferences into 4-hour slots in the morning to accommodate the multiple time zones that we are kind of grappling with. So Frank, your discussion reminds me of John Perry Barlow's initial Declaration of Independence for cyberspace, where he begins by saying, "You weary giants of flesh and steel, you have no business here." And so what he's saying is, what his view is that we are living pre-internet in failed states, okay? And so what we need is some new governance regime entirely. And so this functional sovereignty that you are ascribing to the internet platforms, et cetera, is exactly what John Perry Barlow would have liked. But he would have embraced it, because he would say that the alternative was a set of failed states. And it turns out, I mean, as you've pointed out to the Prop 22 and various other, and the New York City campaigns with respect to Uber, Uber repeatedly has said, hey, to the public, if this regulatory approach passes, that will be the end of Uber. And in other words, suggesting to the public that we'll return to the kind of failed regime of before. And that's a trick, very tricky and powerful argument that it's been able to use again and again. So I wanted to know what you kind of made of that.
Well, that's a terrific point of challenge, and also a point of origin of this idea. And certainly, as someone who is had long experience being with these weary giants, you can't overestimate state capacity, and that I think is going to be, and I think that what we're really putting our finger on here is something that's going to be an enormous controversy in coming decades, right? So for example, you get some people say, looking at sort of, the US's terrible coronavirus response and vaccine rollout, they say things like, well, what do you expect? The state it's a rotten state, and it can't, and of course the state is going to mess up here. And of course, and then others say, well, if only we had been investing in public health for, 10 or 20 years, we would have an infrastructure capable of dealing with this. And so I think that part of the answer has to be that there has to be sort of a long-term rebuilding of state capacity in different areas. And many of the places that we might think of as being, quote unquote, the developed world are actually, under the stress of new challenges, appearing less and less able to address them, right? And are going to have to rebuild and invest in state capacity. So I think that is true. I think also, in terms of a problem that may be insoluble by states, could be one of the problems I mentioned in terms of the bounds of political discourse, right? I mean, I mentioned, and I gave relatively easy cases for myself, like sort of, complete lies about there being RFID chips in vaccines or denialism or things like that. But when you really look deeply at the edge cases or the difficulties, it does become harder and harder, to think about what would be, say, the legitimate state equivalent of the Facebook Oversight Board, right? Would it be the real Facebook Oversight Board, which is recently organized, or something different? And so that's going to be a very difficult question. And, it's something I hope to look into in an upcoming piece, or long-term piece called The Bounds of Political Discourse. But I think it's a great question. But I do hope ultimately, though, that at least with respect to these goods and services, I think in the expressive realm, there's a lot more to be said for leaving things entirely to corporations and civil society than in the non-expressive realm. So maybe that would be a rough and ready distinction where we should be more suspicious of functional sovereignty when it comes to goods and services as opposed to expression. Thanks.